Perez also stated that he had connections with the mafia and he was going to have the complainant killed. The cases are now called 23 CR 2000 and 23 CR 2001. Each of these indictments are styled the state of Texas versus Cameron Smith. That's you, sir.
Yes, sir.
And they charge you with the third degree felony of deadly conduct in 2000 and 23 CR 2000, and the second degree felony of aggravated assault with a deadly weapon in 23 CR 2001. In summary, 2000 case, the number 2000 alleges that on or about October 22nd, 2023 in Jefferson County, Texas, you committed the third degree felony of deadly conduct and with the discharging of a firearm, and 23 CR 2001 alleges the second degree felony of aggravated assault with deadly weapon occurring on or about the same day, October 22nd, 2023 in Jefferson County, Texas. 2000 states that the defendant discharged a firearm at or in the direction of a vehicle and was reckless as to whether it was being occupied. Then 2001 case, the number 2001 is shooting at a particular person. Was that person in the?
These were two different
events?
Yes, sir. It was in the two different complainants on that.
Same night, but two different. Not kind of the same event, but different events. That makes sense.
What does that mean, John?
The other car was being shot in the parking lot. I believe no one was in that vehicle. The other vehicle was being shot at with an individual.
Two different cars.
What's going on here? What's that all about? I mean, I know we unfortunately take this for granted in this county too often nowadays, but this is bizarre. This is like a bad movie. What was this all about? This is not supposed to be normal behavior.
No. My understanding, there was a disagreement between two individuals.
Quite naturally, somebody gets shot at. That's how we resolve our differences now, huh? And you're not even from here, are you? You're from Houston, right? Well, thanks for coming into Jefferson County and making a mess. We got our own problems here with our own people. You apologize? How do you take back firing a gun? Do you grab the bullet before it gets to the person? What do you do? When you shoot, you made a decision and the bullet leaves the chamber. That's it. You don't know where it's going to go. Who's going to? Do you really care? I don't know. It doesn't seem like that. Not the way you're acting. Not the way you acted here. All right. In 23 CR 2000, this is a third degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Agreement's been reached in that case. You would be whatever sentence shall not exceed a cap of 7 years in prison to run concurrently with this next case, 23 CR 2001. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Is that yes?
Yes, sir.
Okay. Go to 23 CL 2001. And again, in summary, this alleges that you on or about October 22nd, 2023 in Jefferson County, Texas, intentionally, knowingly, or recklessly caused bodily injury to someone by shooting at them. What was the bodily injury?
There was a piece of the shrapnel from the bullet had grazed her cheek right there. There was a small cut.
This is a second degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. Sentence shall not exceed a cap of 7 years in prison. To run concurrently with the preceding case. Is that your understanding?
Yes, sir.
How do you plead to this case? Guilty or not guilty? If we follow, if I approve this, you would be sentenced to no less than 2, no more than 7 years confinement in prison or each case. You could be placed on deferred or unadjudicated probation for up to 10 years on each case. But I don't think regular probation is an option. You know, All right.
The deadly conduct it would be, but not the aggravated.
How would deadly conduct be if
Wouldn't that
you're
be-
discharging a firearm? Isn't that kind of wipes, the firearm is used in the commission of the offense. Doesn't that do something that prevents me from regular probating? Think about it.
Yeah, you're
We'll
right, that
all
makes sense.
know what all the options are.
We can be,
So we're going to order a pre-sentence report. We will return back on
January 22nd.
2025.
25 now.
All right. All right. We are called Gerardo Alafa. That's you?
Yes, Your Honor.
And Mr. Adams is here representing you. Earlier, you pleaded guilty to in 24 CR 479 to the offense of arson. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Now, the agreement in this case is whatever sentence shall not exceed a cap of 5 years in prison. So we're looking at, this is a first degree felony, correct?
Yes, sir.
Yeah.
Yes, sir.
So we're looking at
Judge, I offered the minimum,
no less than
but
5 nor more than 5.
they wanted an opportunity to present to the court of argument for probation.
I understand. So I'm just looking at what the options are.
Yes, sir.
He could be placed in prison no less than 5 nor more than 5 years, 5 years flat, please. He could be placed on deferred or unadjudicated probation for up to 10 years. And he's eligible for regular probation then, right? So he could be sentenced to 5 years in prison. That could be suspended. He could be placed on regular probation for up to 10 years in length. How much time has the defendant served, please, on this case? Thank you. How long have you been in jail now? About a year?
April.
April is when you went to jail? Okay.
One of the big things that I was impressing upon my client is he does have extensive employment history. I'm looking on page 4 of the PSI where he's worked at several places. He is very remorseful and sorry for what he's done. And he's asking you to give him probation. And I was going to let him talk to you more directly than me. Do you mind if I ask you a question? All right. Hey,
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Lower your hand.
okay. So, do you accept responsibility for this?
Yes.
Are you sorry for what you've done?
Yes.
And I guess let me get to the heart of this. Could you tell the court good things about you, like something positive about you?
I've never been in a fight with nobody, you know. Probably not human being. I live in school. I like to help people out, work, and be with my family.
All right. And if you're given probation, will you follow the rules?
Oh, definitely.
Will you do what you're supposed to do?
Most definitely.
Stay out of trouble?
Yes, sir.
In these places with the fires, will you totally stay away from it?
Yes, sir.
All right. And are you very, very remorseful?
Very, very good.
All right. And are you begging the court to give you probation, whether it be deferred or whether it be regular probation?
Probation, yes.
State, any questions you want to ask?
Any questions, Judge?
What are you sorry for? What did you do wrong?
Or
Here,
maybe drinking too much and just
what did you do here? How did you set this fire? Tell me about that.
I threw a cigarette in the apartment.
Why?
It was empty. I just threw it just there. So I thought it was out. I was in a hurry. I wanted to go home.
Why did you want to set fire to the apartment? This is a multi-dwelling building, right? It was one apartment in an apartment complex, correct? Right? Everybody? Avery Trace Apartments. Have y'all everybody looked at this?
Yes, sir.
Okay. I mean, you set a fire in one. I mean, there's no reason with some bad luck, the whole place could burn down with multiple people being involved and victimized. But why did you do that?
Maybe because I was kind of buzzed. I saw a lot of roaches running around. I used to live in.
Oh, you were killing roaches.
I tried. to burn
You were
one.
killing roaches by setting a fire, by committing arson? That's what you're trying to tell me?
I would burn one of them, but
Or you want to burn one roach?
but I guess
Are you at war with roaches? I mean, what is this? Is this I don't
I
understand
used to
here.
live in that apartment and they never fixed my apartment. They never fixed it.
You used to live in that apartment.
Yes.
Oh, okay. Now
They
we're getting
never-
somewhere.
They never changed my carpet. They broke my glass patio door.
Okay,
and-
so are you trying to say you were mad at those people who weren't taking care of your apartment as they were supposed to, and you decided you would damage it? Is that what you're saying?
I just threw a cigarette and
You threw one?
to cigarette to burn the boat or something was burning. I just threw it but it was out. I think it wasn't burning. It just started threw it away. I thought I wasn't gonna do that all the damage.
So what were you trying to do?
Me and my brother we moved out of there to a different apartment.
No, what were you doing?
Oh,
What were you trying to do by causing a fire?
the door was open. I just wanted to see how it looked like.
But you set the fire, right? You set a fire and could have burned not only that unit down, but it could have damaged a lot of other units, correct? Why? Why would you want to
I
jeopardize so many people's lives?
But I didn't think about that. I don't even fire no the cigarette. I don't even smoke cigarettes.
Well,
But that's
certainly we could all agree you weren't thinking. Not thinking has a lot to do with your actions on this part, because this is very foolish, dumb behavior you're trying to explain to me. It doesn't really make any sense. Does anybody? Can anybody tell me anything sensical about
I think
what
I
he's
can make-
trying to
I think I can make sense. out of it.
communicate? Really?
Yeah, well, I think the way to
Give it a
make-
try.
I think the way to make sense out of it is, Judge, is that even though intoxication or voluntary intoxication is not a legal defense, he was intoxicated at the time. And even though that's not a legal defense, that's an explanation as to why he was acting the way he was acting. It would go more to mitigating factor, but not a legal defense.
All right. The pre-sentence report is there any objection to the pre-sentence report being made a part of the record?
No, sir.
This stay?
No, sir.
No. Okay, then it is made a part of the record. Paragraph 3. Everybody reads that. Second sentence.
Yes, I saw that.
Witness identified as a name advised she had seen the defendant multiple times because his brother used to live in apartment number 109, but was evicted. Now this fire is occurring in apartment unit 209. According to this witness, this same Hispanic male, the defendant, started multiple fires in the complex previously by setting barbecue pits on fire under the carport. They further explained that she saw the defendant standing across the sidewalk watching the fire as it was occurring. And if that's not enough, well, we have a video of the whole event. As the assistant store manager of HEB says, there's the video. They have video footage of the defendant arriving on the property and starting a fire at the north side of the building. The defendant's pre-sentence report reflects a host of prior convictions, doesn't it? We've got as early as 1994, illegal possession of marijuana conviction is a misdemeanor. He was fined there in Hidalgo County. 98, misdemeanor retail theft, Champaign County, Illinois. And then we get to something interesting in 98, knowingly damaging property in Champaign, Illinois, 18 months conditional discharge. Then in 2000, 12 months driving under influence of alcohol in Champaign County, Illinois, 12 months conditional discharge and a fine. In 1999, He is sentenced to 30 months conditional discharge in Champaign, Illinois for burglary. You just made a mess up there. And in 2001, 3 years prison, unlawful possession of a converted vehicle. Now, that one is an interesting name. I'm not sure, but we're not going to go into it. But unlawful possession of a converted vehicle. I don't know what that means, but he got 3 years for it. It's illegal in Champaign County. I've never heard of that type of crime. And then in 2002, he was sentenced to aggravated criminal sexual abuse in Champaign County, Illinois, sentenced to 24 months of probation. That was revoked because he failed, and he received 5 years prison. So he has at least 2 prior felony convictions. And that was a mess he made in Champaign County. Now he's here in Jefferson County making a mess. Anything else?
No.
Anything you want to add, Mr. Alafa? No? I'm going to find then you have pleaded guilty today earlier voluntarily. You were mentally competent to do so. You understood and you understood the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of arson with intent to damage a habitation, a first-degree felony. I'm following this agreement. You are hereby sentenced. Finding you guilty beyond a reasonable doubt, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You have made a mess in Illinois. Then you come down here and you're making a mess now in Beaumont. Shame on you. I just wish that the punishment could have been higher because you richly deserve it based upon your irresponsible history of criminal behavior and damage and hurting people. You need to fix that. You're dangerous to yourself and others. And I'm sure there was damage to the apartment. And I don't know what that is. Nobody's asking about restitution. I'm sure somebody has to pay for that too. Another part of the mess that you're costing others. You're going to prison. That's where you deserve to be. Anything else? That's all. 24 CR 1109 is called the State of Texas versus Juan Perez. You are Mr. Perez.
Yes, sir.
Present with Mr. Grover, attorney, and the state's attorney. Earlier, you pleaded guilty here in cause number 24 CR 1109 to obstruction or retaliation, a third-degree felony. A pre-sentence report has been prepared. The agreement is whatever sentence shall not exceed a cap of 5 years in prison. So he is looking at no less than 2 nor more than 5 years confinement in prison. And that could be suspended and he could be placed on regular probation for up to 10 years. I see the defendant is not eligible for probation according to the indictment from a jury because of a third-degree DWI conviction in 2021 in this court, correct?
That's correct, John.
To basically sentence him to as a small amount of time as possible. Basically, what happened on this occasion was Mr. Perez was out in front of the HEB. He was outside the store, was intoxicated. I think he had a bottle of vodka with him. He threatened the store people, was arrested for resisting arrest from the Beaumont police officers, one of which worked there and then one of which arrived later. And he just, he screwed up badly and wishes to ask the court for just to give him a break on this case. Now, he has been to prison before. How many times have you been to prison?
One time, the first time I convicted for 5 years, and one was for violation of parole, and then this last time for DWI.
Yes, sir. He has a burglary of habitation from Hidalgo County and DWI, I believe, from Harris County. It may be from this county.
It is from this county.
From this county. And so he has been to prison He has a number of convictions, but not as many as it might appear. It appears that from Hidalgo County, whatever they had down there mostly disappeared. The records disappeared.
So what we're saying is according to these records, he could have been prosecuted as an habitual felon.
That is correct, Your Honor.
So he would have been looking at no less than 25 nor more than life imprisonment because of your criminal history. So how y'all were able to fashion a cap of 5 years is pretty amazing with your rich criminal history. Plus the fact that the charge is threatening to commit murder because somebody called the police, which is their absolute right to do in good faith.
Judge, I believe that, and I'm not trying to say that this is nothing or what he did was not wrong, because it was totally. I believe that what the problem was, he was more of a nuisance out in front of the store, and they wanted him to leave because he would keep people away from the store. Now, I'm not denying that he said what they say he said, because if he did, he did, you know, but I don't think that was his intention. I think that he was just drunk there. He said he was recharging his cell phone on the parking lot of the HEB, which it seems more consistent with him ranting. I would say,
The fact is,
although the court did, I'm not denying that he said what he said.
according to what we have here, this is HEB.
Yes, Your Honor.
Okay, a very important
Yes, sir.
commercial entity here in this town and in others. He was in the front he was begging for money from
Yes.
other people, which is not the right place to do it. I mean,
No.
that's where a lot of people are, but he had been ordered not to be there. You weren't supposed to be there in the first place. There was a no trespass order on you that they had gone through the authorities to try to work this out in a peaceful way so that you would not be in trouble. And that wasn't enough for you.
Yeah, we don't dispute that, Judge. He had been trespass warned by the store and told not to be there. And again, there's not any way I can say that what he did was right, but I think that his intent probably was just to get money, which he shouldn't have been begging there, and he shouldn't have been on those premises, more so than the intent to injure anyone.
Okay, what are you asking for?
I'd say, Judge, I'd ask that the court give him a minimum number of time in the Texas Department of Criminal Justice. I don't think that probation would do any good for him because of his being a transient and having this criminal record.
What's they say?
Your Honor, the state would note that the defendant very clearly has a drinking problem. He has several DWI convictions. His last conviction in this court, which happened in 2021, was a felony driving while intoxicated, and the court gave him the minimum amount of years on that, which was 2 years TDCJ. Now, he hasn't worked on his drinking problem at all. He was drunk when this offense occurred. If he's not willing to take probation and go to SafeP and work on his problems, well, then there's no reason for us to give him the minimum in this case. He told the officer that he wanted to kill that staff member and that he had connections with the mafia and was going to have the complainant killed. And the officer told him to stop making threats, and he said he didn't care about jail time. So obviously, a minimum amount of jail time is not a deterrent for this defendant. We would recommend the max with the cap of 5.
What did you want to say, sir?
Well, sir, I mean, to be honest with you, that report that the officer said that I threatened, I've never threatened anybody in my life, to be honest with
So
you.
everybody's lying here.
Well, I mean, what the officer said, I mean, at that point, all I mentioned from that time was that I would be back, and that was because I was charging my phone. I had every intention of
The officer wasn't there. They were told that by the person at one of the staff members of HEB.
No, he told it to the officer,
I
not to the
believe he
staff
told the
member.
officer and judge wasn't after they had arrived.
All right, exactly. Let's go. All right.
And I'm not sure the pre-sentence report.
I can give you the offense report if you'd like, Your Honor, but he told it to the officers.
Officer Melendez advised while Perez was in his custody, he made statements to HEB staff member who contacted police that he would have them killed for calling the police. Okay. Well, let me read that again. Help me out. Officer Melendez advised while Perez was in his custody, Perez made statements to the HEB staff member who contacted police that he would have them killed for calling the police. I mean, doesn't that say he made a statement to a HEB staff member, the person who contacted the police, that he would have them killed for calling the police? So the only way they would have known that is the HEB person had to have told them that.
Judge, I wasn't there, and so I obviously don't know. And HEB had employed a Beaumont police officer as a second job, and he was on premises, and he was there almost immediately, I believe, Judge. And then, of course, what he did was call for another officer who came, who actually transported Mr. Perez to the jail and all of that stuff. I don't know. Well, I believe we have something from the.
All right, okay. Let's look at Officer Malonsaw. It's Malonsaw.
Yes, Your Honor.
His report began to ask Perez if he had an identification on him. I also advised Perez that HEB employees called for police due to him being trespass warned from this location earlier this year. While searching Perez for identification, he began to turn his head and make vague threats to retaliate against the HEB employee that had called the police. I advised Perez to stop talking and that I would not allow him to make threats within my presence. Perez then advised me he didn't give a F word. At this point, I did not want any verbal aggression or threats from Perez to continue, so I grabbed a hold of him by his arms, told him to walk, and once I turned Perez to face south in order to walk him to the back door to the patrol unit, he let the lower half of his body go limp, went dead weight, fell to the ground, and his head struck the concrete, taking me down to a knee as well, and EMS was called. All right.
He also made threats in the EMS, Your Honor, which is that last
He was
paragraph.
transported from HEB, and this is the one right on College Street to Baptist Hospital. So,
While on the short ambulance ride, Perez made statements he was going to go back to HEB and have whichever staff member called the police on him killed. Perez also stated that he had connections with the mafia and he was going to have the complainant killed. Perez kept stating that there was a black male at HEB he was going to have killed, but the complainant who filed charges for trespassing was the female manager. So he threatens a lot. He's loose with his threatening remarks. Anyway, go ahead. I think we understand what happens here. He wasn't supposed to be there. He's intoxicated, and his big mouth threatening behavior is getting him in worse trouble than he would have gotten had he just followed the rules, not been there, or followed what the police told him to do, and that was leave. But no, you wanted to make a spectacle out of yourself. You got the attention now.
no.
And these poor people. Here's another thing: is according to pre-sentence report, you're looking at 25 to life. They should have indicted you as a habitual felon. Any felony offense above a state jail felony, you should be looking at 25 to life. Make something better out of your life instead of being just a drunkard who threatens people. My goodness. But you don't have any wherewithal with your criminal history to be committing crimes. You're held accountable for every crime you commit and your criminal history, which exacerbates the punishment. But you know that. Now, your lawyer has miraculously limited your exposure to 5 years when you should be looking, according to history here, a minimum of 25 up to life for making a mess. HEB is one of the leading commercial entities in the city and many other cities, and tons of people are there. I know. I drive by that place, one of them anyway, and they're always packed with people. And making a mess in the front of the stores ruins everybody's life who trying to just go get food. Okay, go ahead. Let's go. We got to move on. You're asking for
as low a time as possible, but again, not for probation,
yes, sir.
but for he should receive a final conviction
Okay.
and be sentenced to.
Okay. Finally, Mr. Perez, anything you'd like to say?
Well, sir, to be honest with you, I mean, it's like I said, I mean, all this, I never threatened anybody, but the purpose of all this,
Wait,
I mean,
wait,
like I said,
That's not what the police say.
I know it's my word, and that's why I plea bargain, because I know I'm not gonna win. I mean, I know the situation looks bad, but I didn't do it. I mean, I didn't.
So you're not guilty of this crime.
threaten.
So
Pardon, sir?
you're saying you're not guilty of this.
I think what he's saying.
No. Here's what we can do. I'll reject this deal. If you're not going to admit responsibility, I'll reject it, and then we'll set it on the trial docket and let the state have an opportunity to maybe analyze this case again to determine whether other charges ought to be brought. How about that as an idea?
I'll admit that I'm guilty.
Well, you say you are under oath.
Yes.
According to this plea agreement, you said you are. So I'm saying don't be telling me you're not guilty of the crime. You're lying one way or the other, but you said under oath you were guilty. Okay. You got to be honest. Start being honest for a change. If nothing further to add, I'm going to find you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You will be given credit for all time you have served in accordance with this case. That is all.
Thank you. Good luck. Bye-bye.